Okay, well, everybody, welcome to our final panel of the day, A View from the Bench. And I'm going to do a little make a few administrative announcements first, just the usual. Turn off your cell phone, please. And panelists also, because we could get some feedback. And so this is a fairly tight schedule. Judge Tatel actually has to leave us immediately at 7. We're going to try and reserve some time for some questions, because I know you're an irrepressible crowd, and you will have many. So with that, we're going to get started. As you know, we're going to talk about various aspects of the life of a judge and becoming a judge, and what has inspired these wonderful judges to make this their career path. Perhaps there may be some discussion about clerks and how we approach those issues. There may be some questions along those lines. But the first thing I just wanted to say before I introduce the judges is, if I had a picture of the perfect judiciary, this is what I would be asking for, right? This is my dream federal bench. So anyway, thank all of you for being here. I think you are all very familiar with these esteemed judges, and so I am not going to go through the bios because they're very lengthy, and each of these judges has an extraordinary list of accomplishments. So I'm only going to go through the names and the courts, and you can read for yourselves all of the wonderful things that they have done. So starting from my right, Judge David Tatel, who's with the Court of Appeals for the District of Columbia Circuit. And then Judge Beverly Martin, who's with the 11th Circuit. Lucy Coe with District Court for the Northern District of California. To my left is Judge McKee from the 3rd Circuit. And then we have Diane Wood from the 7th Circuit, and Gary Feinerman, who is with the Northern District of Illinois. So, I don't want to spend much time hearing me talk, because I'm not a judge, and I don't really have any great insights into being a judge. So I'm going to ask a very broad question that I hope all of you will address and reflect upon, sort of a little bit of what was the reason that you decided that this was what you wanted to do with your life, and what were the steps that you took to move along that path. And so, maybe we'll ask the sort of more recently appointed judges first to sort of reflect on, sort of the recent process and what you experienced, and maybe we can have a little comparison to how maybe it used to be a little bit before that. So maybe Lucy?
There are a lot of questions packed in that. I would say first I got interested in law just based on my experiences growing up in Mississippi from 1972 to 1981, and then from Oklahoma from 1981 to 1986, and just feeling the power of the law in people's everyday lives. And when I went to law school, I thought I wanted to be more of an advocate and to be more of a lawyer. And it was only in the process of practicing different areas of the law and seeing how important it was to have fast, fair, and effective judges that I thought, I would like to be a part of that. The process in California for the trial court is governed by the 2 senators who are of the same party as the president, and they each have their own committees that take a formal application, they do an interview, they make recommendations to the senator, and then the senator makes recommendations to the White House. And then from there, the White House counsel's office and the Office of Legal Policy of the Justice Department take it from there.
Mm-hmm. Well, let me ask you, Gary. So what, besides being on the board of advisors for the ACS chapter in Chicago, made it possible for you to become a judge?
Well, not much else. That's
what we like to hear.
Worked. I think that the obvious thing, and I I kind of mean this to be funny, but it's true, is don't do anything that will disqualify you from being a judge. Pay your taxes. And don't commit crimes. And there's something else that is equally important, but perhaps less obvious. When our process in Illinois was similar to the process that Lucy described in California, where Senator Durbin had a commission, and they accept applications, and then they go out and they ask lawyers in the community, and they ask judges about the applicant. And it's very important to be nice. Be nice to people on the same side of the case as you. Be nice to people on the other side of the case as you. Because if you do want to become a judge, those people will be canvassed. And it's not like I thought, well, I want to be a judge, so I have to be nice. It's a good thing to do, even if you don't have judicial aspirations. And it doesn't mean, pull back substantively. It's just the old saying: learn how to disagree without being disagreeable. And that, I think, will carry you a long way. And then, other than that, it's very circumstantial. The planets, depending on what state you are in, the planets have to align in terms of putting yourself in a position where lightning can strike, and you come to the attention of somebody, and somebody on the committee takes a liking to you and recommends you to the senator, and then the senator recommends you to the president.
Well, I'm going to ask Judge McKee now, because you, I think, maybe the only judge on this panel who served on the state court. And so when you reflect a little bit about on that experience and how you went from, you have a very varied background in terms of being a prosecutor and private practice also, I think. And can you talk a little bit about, I think, what some of the challenges were and what some of the things that you found in your career path that were helpful?
The state court process, that could be a day in and of itself, especially in Philadelphia. That in order to understand the way the judicial selection for the state judges work in Philadelphia, you'd have to have a course called Philly Politics 101. And no one under the age of 18 should be allowed into that course. It's a the very first event I went to, which was billed as a fundraiser, that the person who later became governor of the state introduced me to somebody that I had a wire on for about 3 years. But he was out now, and he was a political consultant, and people were paying him to bring in support from South Philly. It's a very different situation. When I went through the federal confirmation process, it was like light years different. I agree with what Gary said. You can't plan your life to necessarily become a judge and scheme to think about what I should do to get there. It's kind of like trying to predict where the ninth neutrino to emanate from the sun is going to land in the universe after it leaves the sun. You can't do it. There's too much randomness involved. But one thing which really is important is your reputation. And I really want to express, especially to the young folks, excellence, civility, as Gary mentioned, but being excellent in your work product, making sure that your name is synonymous with excellence, and zealous but ethical professional advocacy, and a demeanor which also goes back to what Gary said, a demeanor which invokes the old saying of be nice to everyone, because the measure of someone is not, it's how you treat people you don't have to be nice to. That is so important. And it's hard to get there if your reputation suggests you should not be there. It's hard to get there now if your reputation suggests you should be there. It's very difficult. And if you've done anything to be very thoughtful, it's very difficult now to get there. But when I ran, it was the senators were not they weren't really involved at the circuit level. They're still not that involved, depending on the state. But my senator, Senator Wofford, happened to have a good relationship, a very unique relationship with President Clinton. I did not know Senator Wofford, but someone whom I knew well, who knew Senator Wofford well, knew that I had been aspiring to the federal bench for a while and arranged for an interview. And the week before the interview, I read Senator Wofford's book. Fell in love with the man. I mean, this was a guy was my idea of a public servant. I'm very proud to consider myself a person of the 60s. I'm a product of the 60s. I have no problem saying that. I'm a liberal. I have no problem saying that. I don't let that interfere with my jurisprudence, but like any good judge, I think my morality informs the interstices of the ambiguities of statutory interpretation, as all judges do, whether they admit to it or not. That's the way we call the game as umpires. But anyway, I fell in love with the senator, so I went in. We had this half-hour interview, which turned out to be a 3-hour meeting, and then out of that, the stars aligned, as Gary said, and things kind of broke right for me. But the atmosphere in the Senate was very different. Senator Biden, chaired the Judiciary Committee. He's from my alma mater at Syracuse. We were research assistants for the same professor at Syracuse. He started referring to me as his homie, which didn't hurt. For some reason, he got it in his head that I was from Wilkes-Barre, Pennsylvania. I am not, but I didn't think it would be polite to disabuse him of that notion. So homie got confirmed with on a unanimous voice vote. But that's not, as you know, that's not the way it is now. Now it's just ridiculous. It's almost obscene the way the process is now.
And I made an error. Actually, I totally forgot. Of course, Lucy was also on the court in California, the state court. And I don't know if you want to mention a little bit of how your transition went and what are some of the things that you see that are different in the different court systems.
Sure, I'll do that. But I also wanted to encourage anyone who is here from California to also think about the state courts, because I know we tend to focus more on federal courts, but in many respects, comparing the two, I think you can, in many instances, have more of an impact on people's lives in state court than you can in federal court. And so many of the cases in federal court is largely fighting over money. It might take different forms, but ultimately that's what the dispute is over. And in state court, you're dealing with families and who should get parental rights, and drug court and mental health court. And in so many ways, you're more sort of directly on the ground influencing how people live in our society, which I think in federal court is a little bit more removed, although we're developing reentry courts, which may sort of play that sort of therapeutic court function, but it's nowhere near as prevalent as it is in state court. And just quickly, for anyone who is in California, we have sort of a baseball analogy for state court appointments. You initially put in an application, it goes to the governor's office, the judicial appointment secretary, or whoever's playing that role sort of makes an initial cut through a county local committee that does the same kind of vetting that was mentioned previously, of calling around, getting reputational information, and then they make a recommendation of who goes to the next level, which can be a bifurcated system of a county vetting process, which also does the interview and calls, but then also has a statutorily created statewide body that does its own vetting, investigation, interview, and then they make a recommendation to the governor's office, and then the final interview, depending on the administration, is either with the judicial appointment secretary, or in some rare instances, maybe for the Court of Appeal, would be with the governor, him or herself. So it's sort of a first base, second base, third base analogy, and politics does matter, but it really depends on the administration. My understanding from talking to people in Governor Brown's administration is that he wants to make the decision himself and get the full credit for the appointment. So he does not want letters from a lot of local elected officials, which was very different than how Governor Schwarzenegger did it and how Governor Davis did it and previous governors.
Can I just say that the current governor has made some excellent choices.
I agree.
Yes.
I agree.
Yes.
So the bottom line is find out how the current administration is working, and what sort of opinion leaders they check in with to determine what's your strategy.
So let me ask Judge Tatel. What were the things that brought you to want to become a judge? And have you seen the confirmation process change since you've been on the DC Circuit? And just as a footnote, I'm sure you're probably happy to have new colleague who I think is getting sworn in on Monday, and Sri is around here somewhere, but I imagine that makes life a little bit easier around the court. But what was, what was the precipitating factor or factors that made you think that that was what you wanted to do with your life?
Well, I was thinking when I looked at this program, you know, when I was, you see, you've gotten to the older judges on the panel now. That was what we were doing. You said it in a very nice way, Carol, but I knew what you were doing. So when I was a young lawyer, I don't think anybody would have had a meeting like this. We didn't aspire to be judges. My generation of lawyers, you know, we admired federal judges, and we wanted to argue cases before federal judges, but I don't remember sitting around with my contemporaries talking about how do you get to be a judge. And speaking only for myself, it wasn't part of my career plan. I worked with a law firm. I served in government. I ran a civil rights organization. I developed what I thought was a very successful and satisfying law practice in Washington. And I had not, I wanted to serve in government. I very much wanted to be in government. And if I have any regrets in my career, it's that I never served in the Justice Department. But I did serve in the government during the Carter administration, and I found it very satisfying. And when President Clinton was elected, I was interested again in serving in government. I had not focused on becoming a federal judge. It just wasn't something I had anticipated. I am very pleased it happened for me. And if you look at the D.C. Circuit, which is the only court I know, I mean, I can't give you any advice about being a state judge or being even a federal district judge, but if you look at the D.C. Circuit, I don't know, is anybody here would like to be on the D.C. Circuit? If you look at my colleagues, there are 8 active judges and a handful of senior judges, and there are as many different career patterns as there are judges. And I guess all I can really say is that I think, to echo a little bit what Ted said, I think the only thing that I'm sure will help is to develop the best practice you can, whether it's in private practice or in government or teaching, to develop a reputation as a fine lawyer, to be committed to improving the quality of legal representation in the country, to serve in government as much as you can, to be a very, very good citizen. I think if you do that, your chances of becoming a judge are much better. In terms of the confirmation process, it's a totally different world than when I went through. I've just finished my 19th year on the D.C. Circuit. I was confirmed by the Senate in 1994. It's a very different situation then. The confirmation process was far less contentious than it is today. And I guess, again, I go back to saying that, you know, the most important thing to do at this stage is to focus on the development of yourselves as highly respected, highly competent lawyers devoted to making the legal system work as well as it can. And to the extent you have an opportunity to serve in government, you should do that. And if opportunities to become a judge come along, I'm sure there's political aspects of that play a role in it, but I'm probably not the person to have much advice on that.
So Judge Martin, you've served on both the district court and the appellate court, and we're very glad that you're on the 11th Circuit. Can you talk a little bit about your different experiences and sort of, you know, what was the district court experience that gave you the right background to sit on the 11th Circuit, and are there things you miss about being a trial judge?
I do miss being a trial judge. I loved being in the courtroom and you know, the unpredictability of it. I really enjoyed it. And I don't think I did anything that qualified me to be on the 11th Circuit.
We disagree.
But here I am. So I'm trying to learn how to do that job and trying to learn how to do it better. I want to say, listening to all of these tales of merit selection committees, I don't think I could have gotten through a merit selection committee. I never went through one. And when I was nominated for the district court, there had been a long period of vacancies, and people from Georgia remember this. There was a vacancy in the Northern District. Well, I was in the United States Attorney's Office in the Middle District, not even the same district. And there was a man put forward by our Democratic senator at the time, Max Cleland. And I think he stayed in the process something like 15 months or something like that. And then he finally he never got nominated. So he finally just pulled out. And then they nominated a very respected state court judge. And she was nominated very quickly, but she couldn't get a hearing. And then the time came for her to qualify for her state court position, because she was still serving that. And she, the federal position was too uncertain, so she withdrew so that she could qualify to run for her state court position. Well, at this point, it was January of President Clinton's last year in office. And so they realized that the FBI background checks were taking about 6 months, and they knew that if they had to wait for somebody to go through a background check, there wouldn't be any time for the rest of the process. So they said, we need somebody who has a current FBI clearance. This is the truth. This is true. And so they called the United States Attorney in Atlanta, and he said he didn't want to do it. And so I have this picture of them sitting around going, is there anybody else? This is true. And so literally, I was sitting at my desk, and someone from Senator Cleland's office called and said, how would you like to be on the federal bench? And I really called my father, and he and I agreed that there was no way I would make it, because just the process had been drawn out so long, but that I would try it, that it would be interesting, and I got confirmed. So.
And was it interesting?
I was probably treated better than I deserved through both of my confirmation processes. I mean, you hear such horror stories the other way. I was fortunate enough not to experience
We would
that.
like your Georgia senators to do a little bit more in the way of nominating people like you. So Judge Wood, you've done a lot in addition to being a judge in terms of teaching and working in the government. When you have students come to you and talk to you about what it's like to be a judge, or how do you get there, what kind of advice do you give them?
It's very hard to give generic advice, especially because the students who are coming now are facing the world of 2013, or actually they're really facing the world of 2025 or something down the road. And I would introduce just a note of caution to all of this. It's great to have a good reputation. You should, and this is what I always try to do in the bench as well, disagree on the merits when you disagree with people, and give reasons. And if you see things different ways, that's fine, as long as you're behaving in that way. But from time to time, we can all think of moments that are gut check moments. If you go all the way back to the 1980s, there were people who felt that Robert Bork didn't belong in the Supreme Court. Or if you look at the 2000s, there were people who felt that the torture memos were a bad thing. And they wrote op-eds, or they wrote articles, or they were in a position where they just believed that they needed to say something. Well, good for them. I mean, I'm a huge admirer of anybody who stands up and says what needs to be said. But in a highly politicized world, that sometimes comes at a cost. And I can think of people, not just judicial appointees, but appointees for executive branch positions, who have wound up somehow being too hot to handle because they took a position on something that was a very contested point at the time it came up, and you just have to decide, what kind of person you're going to be. And if you have, in fact, taken those kinds of positions, but you've done it in the right way, then you may be fortunate enough, if opening comes up on a court, that you will nonetheless, a federal court I should say, that you will nonetheless be considered. Illinois happens to be a state where at the state court level it's basically an elective system. So that's a whole, as Judge McKee said, that's a whole different program that we are not probably the right people to discuss. But at the federal court level, of course, excellence is necessary. Our court is like the DC Circuit, and I think all of them. We have some people who came from a background of prosecutors, U.S. attorneys' offices, the Department of Justice. We have some people who've come from an academic background. We have some people who've come from private practice, although actually not so much. We finally have some people in the district court in the Northern District of Illinois who do have a private practice background, and we're very happy to see them. But a variety of paths lead one to the federal court. And I tell the students, there's no one path that's going to work. You just have to pick yours and do the best you can at it.
Well, I'm going to change the focus a little bit, and partly because I'm sitting next to Judge McKee, and we had this wonderful program, now it was a couple of years ago, and ACS, along with a number of the diverse bar associations, Justice at Stake, published a book called The Path to the Bench. And it was designed to have a kind of step-by-step explanation of how do you actually go through the process in whatever state you're in of being considered to be a federal judge, with the idea that we wanted to make sure that there was a larger pool of people who was being encouraged, particularly minority and women applicants, as well as people with a diversity of experiences. And Judge McKee was wonderful and did this sort of kickoff program with us, and you had some really interesting stories to tell about sort of how you were terrific about talking about how sort of your different background had been instrumental or influential in any case in your conversations with your colleagues and the progress of how cases end up playing out. And I don't know if you want to talk a little bit about that.
Oh, we have to. This is a bad time to ask because it is, as Tom Cohen yesterday, he's had a case this week, which I'm still not, the blood is still dripping down. It was a case which was a summary judgment case. I don't know how in the world this could be tossed out on summary judgment, but it was, and I couldn't, the one vote I know wasn't there. But the second vote I thought I could get, and I just couldn't get it. So it's not a good time for me to talk about that, because I thought it was totally ineffective. I wrote a note to one of my former clerks crying on her shoulder, and she just said, next case, basically, get over it. But
Tough clerk.
well, she is tough, but that's why I love her so much. She's great. She helps me with that kind of stuff. Different backgrounds, I think, and I won't mention one case by name because it came up publicly a while ago, but we have different perspectives. And it goes back to what I said earlier about how your experiences inform you as you interpret the interstices of certain statutes or the ambiguities of case law, and we all do it. We have to rely upon something, and if we don't rely upon our personal experiences and orientations, I don't know what we rely upon in trying to figure out what Congress intended or how the case law should be applied. And there have been situations where I think my presence has made a difference in changing someone's mind. I'll also say one of my former colleagues, and I won't mention which one it was, it's not Sam Melito, so don't jump to that conclusion, much more conservative than me, and a couple of times he changed my mind. And I will share with you that this happened very recently on a case, and it was filed, I think, this past week. I wrote him, we had an en banc opinion, and it was a situation where we en banced an opinion that had no dissent from the panel, which is relatively rare. But we did en banc it. So after the conference, we decided the panel was wrong. There was no one to assign the majority opinion to. Usually you assign that to the dissenter. And so I took it myself at the request of a couple of my colleagues. I don't like to hide these things. I like to do it more democratically, but a couple of my colleagues suggested I take it. And so I did, and I circulated a draft that I thought was very good. Not to pat myself on the back, I thought it was a really solid opinion. But it was a case where, frankly, I did not like the result at all. But I really thought that that was the result dictated by law and some Supreme Court dicta, but nothing directly on point. But it was pretty clear to me what the Supreme Court had in mind in this one case with the pretty pointed dicta. And my colleague who wrote the lead dissent circulated a dissent, which was incredibly powerful. And frankly, it made me rethink the majority position. I was not at all sure they were right for a couple of reasons. One, I thought his reasoning was probably superior to mine, and I liked his result a lot better. We all did. Nobody in the majority liked where the law took us on that. And so I sat down and I started thinking about, should I just flip and send a note out to the court saying, I've read Judge X's dissent, I think he's right, I'm going to join him, and the next in line in the majority will have to reassign the majority opinion. I'll join the dissent. But as I went through it, I saw some things in his dissenting opinion that I had to respond to. Even if I was going to join it, I wasn't comfortable with it. And as I went through it more and more, I began rethinking my own position, and with an eye toward joining the dissent. And as I did that, the majority position and the majority opinion that I had written really became crystallized and I think strengthened. So I made some changes to the majority opinion that answered the key points of the dissent. One statute he had quoted that I had to hold myself back, because had it been a different colleague, I would have taken a zinger on him. But it was an off-the-wall citation. But I didn't. I restrained myself, because we are very collegial, and I didn't want to upset that. But anyhow, I sent back a revised dissent, and I sent a cover memo basically saying, this really shows the elegance and the beauty of what we do, and the public never ever sees this. The dissent was so well crafted and so well thought out, it caused me to rethink my position, and in the process, the majority opinion that I'm representing became much stronger and more carefully thought out. And my guess is, I said in my cover opinion, it turned out to be true, that when my colleague responds to this by changing his dissent will be much stronger. And he circulated his dissent a few weeks later, and it was a very strong dissent. I think it was wrong, but I think, I really do. And I held the majority, but I wasn't sure I was going to hold the majority. But that give and take, and some of that was not a situation informed by my own experiences, because as I said, I didn't like the result at all. But I really thought that was what the law dictated. There have been other situations where my experiences have informed, again, how I would approach a problem, where being able to share my experiences, going back to the case I mentioned earlier, and I'll start with it. It was an immigration case. The immigration judge had found that the alien involved was not credible. And the reason that two reasons. One, in testifying, very, very common in immigration court, the alien did not look the immigration judge in the eye, and the standard jury instruction that you give to jurors, which is total nonsense. You tell jurors that you judge their demeanor, judge how their body language, they look the questioner in the eye. Well, any seasoned trial attorney or judge knows, well, that's bull. You can't tell. I firmly believe this. Maybe some of my colleagues will disagree with this. You cannot tell if someone is lying by their demeanor on the witness stand. With some cases you can, but as a general proposition, you can't. Really experienced liars will get past you every time if that's your test. It's just not true. But in this case, the immigration judge said, well, he didn't look at me. And the immigration judge doubted the substance of the story. The story was that he got to the border by bribing one of the local sheriffs, the equivalent of a sheriff in this community, $25. The judge wrote an opinion saying, I don't believe in no law enforcement officer would risk their entire career in imprisonment for a $25 bribe. Well, and he wasn't truthful because he didn't look at me. And I sent a note to the majority author, because I'd been in some third world countries, and I said, in some cultures, it's disrespectful to look someone in the eye, and if you do a modicum of research, I'll think you find this person is from such a culture. The fact that he didn't look the judge in the eye means absolutely nothing other than culturally he had been sensitized to not look an authoritative figure, anybody else in the eye. And in terms of the the other indicia of lying. If you look here in the United States, I did some research. $25 in that jurisdiction turned out to be about half of the per capita income of the average person. If you translate that into the U.S., how many times do we know police officers and other law enforcement officers have gone to prison for taking a bribe, much less than that? It doesn't make any sense. He came back with a memo saying, well, basically, Abbott, there was evidence that he testified that he didn't seek medical treatment for the wounds that he had for 2 days. And I wrote back suggesting to him that where he was, there was no hospital available, there were no police records. Another, and I'm going to go on with this, but one of the criticisms was that he didn't have any witness reports to corroborate his story. He said he was beaten when he challenged the local authority. And I said, well, do you know how difficult it is to get bystanders in Philadelphia to step forward and give witness statements? And that was a situation where I think the different perspective, and finally he agreed and relented. The immigration judge's findings was found not to be substantially supported by the record, which is a very, very difficult standard to meet, and it was thrown back for findings of fact, and we asked the BIA to send it back to a new immigration judge, which they did. That was one example, and there are not many of them, where I thought being there and having a different set of experiences can make a difference.
Judge Wood, do you have any similar experiences, or have you seen how a more diverse judiciary has affected the way that the cases progress?
Yes, and what I would say, and I'm primarily right now going to talk on the civil side of the docket, so many cases reach us on the civil side from summary judgment. So we're engaged in de novo review, and we're looking to see if the facts that it's usually the plaintiff has managed to put together from depositions or from whatever else they've done, maybe some documents, is this enough to create a genuine issue of material fact? So suppose it's an employment discrimination case. I've seen instances where people don't understand what a particular environment was like for people. I remember, not to be too graphic about it, having a discussion with my law clerks one time. It was a hostile work environment situation, sexual harassment, and the guy hadn't actually touched sensitive body parts, but he was sticking his tongue into this woman's ear. And my law clerks and I agreed that the yuck factor was really serious. And in fact, worse probably than being groped in certain ways. So just having some sense of what the on-the-ground reality is like. And if you had a room full of men, actually there was another experience on the opposite side when my colleague Dick Posner caused me to practically collapse in laughter on the bench. This was a case, another employment discrimination case that arose from sort of a factory floor setting, and there was a woman supervisor and a man who was apparently not terribly happy that he had a woman supervisor. So he alleged that she was sexually harassing him, but he wound up being fired by the company on the ground that it was a trumped up charge. And so his basis for the allegation was that upon one occasion, she had come up to him and was kind of bending down to show how to work a particular machine, and she sort of brushed against him on the side. And he said, well, she's brushing her breast against me. And in the middle of the argument, Judge Posner said, can we be real for a minute here? What man is going to object to that? So yes, experience does matter.
So I'm going to open it up to questions, and while people raise their hands, I'm just going to ask Judge Tatel and Judge Martin if they've had any other similar types of experiences on their appellate courts.
No, but let me just mention something about a different kind of diversity, which is that my court consists of judges with very different experiences as lawyers. Some of them were law professors with expertise in different fields. Some have been district judges. Others have been practicing lawyers. And most of the members of my court have many, many decades of experience doing what they're doing, and I think that produces a far better court. I think we all learn from each other's experiences as judges, and you know, it wasn't planned that way on the DC Circuit, but the fact is that the different experiences, just in terms of background and what we've all done, produce, I think, a better court and better decision making, because we all bring different life experiences and different expertise to it, and that all produces, I think, better decisions. So.
I don't think I have anything
No,
to add.
okay. Do we have questions? No questions? All right, then I'll keep going. So, Judge Ko, speaking of diversity, you are the first Korean American to serve on the Northern District, I believe? Korean American woman or Korean American?
First Asian American.
First
on the
Asian?
District judge.
District judge, and probably the first Asian American who grew up in Mississippi and Oklahoma.
The only Asian American who represents.
In terms of, and so, has that felt like an extra pressure on you, or I mean, has it? I mean, it's obviously very special, and everyone is very proud of you. But is there a countervailing piece of that that's hard, or?
I think there's an extra pressure to do a good job, because if people think, oh, do you remember that last time that person? Oh, that didn't work out. I feel like that will make it worse for the next person. Mm-hmm. So there is, I think, an extra pressure to work very hard and try to do the best job I can.
Mm-hmm. And do you get a lot of support from your colleagues? I know you don't sit in panels, but how do you interact with the other judges in the Northern District?
The other judges have been fabulous sounding boards for talking about cases, or when there's something. I had virtually no class action experience when I joined the bench, so I had to call. My former chief is here, Judge Walker. I called him, and they've been really generous about giving advice, because we have such a generalist job that it would be impossible to have had experience in every statute, every process that you have to go through in the wide variety of cases that we get assigned to us. So we really, really rely on colleagues to give advice, to be mentors, to be role models. And I call upon them a lot, and they're always very generous.
Let me add, we had, when I joined the court, I was the second woman on the 7th Circuit, and a few years later, Ann Williams joined our court and became the third woman. We now have Diane Sykes, so there are 4. But when it was Judge Rovner, Judge Alana Rovner, and myself and Ann, a day came when it was a panel that was 3 women. And it was the first time this had ever happened in the history of the 7th Circuit. And we were all very cognizant of it, and everybody in the courtroom was, for about the first 2 minutes. And then the arguments just proceeded, and I was actually delighted to see how the lawyers and everybody in the court, we were just 3 judges, we were doing our job, and I thought it was nice that although it was worthy of recognition, it wasn't the only thing that defined the day.
On the flip side, I remember a panel not a while back. There were 2 of my female colleagues and myself, and whenever, one lawyer especially, when he addressed me, he'd say, "Your Honor." When he addressed my colleagues, he'd say, "Ma'am." So he'd say, "Yes, ma'am, no, ma'am." I finally said to him, "Is there some reason why I'm honorable and my 2 colleagues are not?" And he said, "Excuse me?" And I said, "Well, when you address a judge, asking Judge Y, it's ma'am. When you address me, it's Your Honor. Am I missing something here?" And he said, "I'm sorry." He had no clue that he was doing it. And then after that, he was so ingrained in him, he wasn't even aware of it. Both of my colleagues they were slipping one another notes. They were very aware of it. And one of them was about ready to kill him, and she could have done it too.
Well, Judge Feinerman, have you had the same experience as Judge Ko in terms of the interactions with your colleagues and the kind of support that you get?
Yeah, absolutely. We, of course, sit alone, but I've leaned very heavily on my colleagues who have been very gracious with their time and their advice, because as Lucy said, it's, the federal jurisdiction is like this, and unless you've been practicing law for 100 years, you could not possibly have done everything. And so there's a tradition on our court, as I'm sure there is on Lucy's and other courts, where the judges who've been there for a while, it's an open door policy, and they always take my calls, and they're very, very generous and good with their advice. So yes, that's been very helpful.
So I don't know if we have any questions. A question? Yes, sir.
I think that there are many, many people in this room that would appreciate if the panel would talk a little bit about your clerk selection processes. What you go through when you're winnowing through, hundreds of applications and what you're looking for and those kind of things.
Wanted to start with Judge Tatel and go around.
Well, I'll just say two things. One is one of the very best parts of being a federal judge is having law clerks. It is very special to be able to spend one's day with 4 very smart, very interesting young people who challenge you all the time. It's a great part of the job. In terms of clerk selection, I can only talk about the federal side of it. I think the selection process is, to be totally candid, an embarrassment to the federal judiciary, because the judges have been unable and unwilling to agree on a rational, a simple system that portrays the judiciary to young lawyers as a rational institution. And I don't see the system correcting itself at all. I think it's a very troubling part of our system. And as you know, the system pretty much fell apart this year. So we're back to chaos. For myself, like everybody here, I get hundreds and hundreds of applications. And the fact is, I can't look at them all. I rely on law professors and district judges who I trust, who call me up and identify people who they think would be compatible with me. I don't know any other way to do it, and I've given up any hope that the federal judicial system will come together on a rational system that we would all hire together in the 3rd year of law school. It's not going to happen. So.
That's my experience too. There's so many people that would be great clerks that never get the opportunity. I mean, it's embarrassing to me because you have so many people that have applied and you don't even know who they are because there's such a mass of them. You can't look at them all. I mean, that's horrible, isn't it? As much work as goes into these applications. So I don't like that. I mean, the good news is the process brings me remarkable young people that enrich my life, professionally and every other way. So it's broken. I don't know how to fix it. So I've come to do the same thing you do, Judge Tatel, and that is rely on law professors and deans to call me and say, this is the person from my school who I think you should take this year. And it's a system that reliably turns out good law clerks. I have one of my law clerks' fathers in the crowd tonight, Mr. Bierman.
So either my law clerk or I will look at every single application that comes in, and if it's probably not in the ballpark, I'm sorry to say we generally recycle it right away. But if it looks like something that we're interested in, we'll keep it, but then we have sort of general hiring periods. I would say on our court, there's a preference for people with experience just because we're very high volume, and it just seems to help in terms of speed to have someone who's either clerked before or had a lot of writing experience in a previous job. So we do generally prefer former clerks, definitely, but people also have work experience.
I agree with what's been said. I've kind of a very atraditional, kind of very strange practice. I am never on the hiring cycle. My clerkships are deferred way out into the future. I'm trying to get a handle on that, but they're still substantially out into the future for the reasons that were mentioned earlier. As Judge Martin said, you encounter these folks who are so phenomenal. It's not really fair to say, look, you can't clerk for me. So I'll sometimes say, look, I don't have any openings until 2015. If you want to defer and do something in the meantime, that's fine. And they'll most of the time will say yes. I'm now hired out till 2015. I thought I was the only one on the court doing this. I found out this week one of my colleagues only has one opening left for 2016. And another colleague, because this kid was so good from the University of Virginia, I really liked him. Really intense public interest background. I didn't talk to him on the phone. I didn't want to have him undergo the expense of flying up to Philadelphia to talk about a clerkship that didn't exist. But I spoke with him on the phone at length. He'd done some really interesting things with organizing lacrosse leagues in New York City with some at-risk kids and kids who had been told they couldn't learn. And by 2 years after they were in his program, they were all in regular academic courses, some of them at the top of their class. Just an incredible kid who was in Teach for America for a few years. So I called one of my colleagues who played college lacrosse and said, you know, I can't take this kid. Are you interested? And he said, look, I don't have any openings till 2016. And he said, I've got 3 or 4 people I'm looking at for that year, as do I. So it's really come out to a situation. Names percolate to me either usually through professors whom I respect, sometimes law school deans. There's one program I've been involved in the selection process of very early on, and I've gotten an embarrassingly large number of clerks from that, and I just stay in touch with them through the years. And so there's this network of folks that I know, and I kind of pick from them, and I guess with me the trick is getting into that network, and it comes from...
That's why we brought you here.
Well, we got to you 3,090 here, I guess. But that's how it works for me. It's all of us want somebody that we're going to love working with, and that's, as David said.
Judge Wood.
Well, I'm going to draw a comparison between the way it's working now and the way it worked many years ago when I was a law professor full-time at the University of Chicago. In the days before, you know, it's kind of the Stone Age, right? The days before technology, I used to advise the students, you know, come up with a list of, you know, at the most 50 judges that you think you would like to work for based on whatever, you know, their geography or their reputation or district versus court of appeals. And they would, and even that seemed like a lot. But technology has changed this entirely. People who are applying on the Oscar system, excuse me, I mean, you can apply to every federal judge in the country, you know, by hitting a button. And I think that's one of the things that's giving all of us these vast numbers of applications to wade through. These kids are not applying. I mean, I would love to think they're applying to, you know, I'm like the summum bonum, but they are, in fact, applying to lots of different judges. They've been convinced, correctly, I believe, that clerking is a great experience. And so we're all victims of this over-application phenomenon. And I have the same pessimism that David has about whether this is likely to change at all. I don't really think it will. In my own case, I take 3 clerks. For some reason, that works as a good number for me. And I do not hire beyond whatever the year is. Now, this year I did my hiring at the end of January and early February for 2014 starts, which was way earlier than it had been. But rumor had it that the DC Circuit had abandoned all time frames.
We heard that same rumor.
It's nice to have somebody to blame. Actually, every federal judge in the country had contributed to the breakdown of the system. I'm not blaming Judge Tatel.
We simply declared the obvious, that the plan was gone. The DC Circuit stuck with the plan all the way up to the end.
And the DC Circuit was correct that the plan was gone, but they were the ones who said the emperor had no clothes, right? They were the ones who, and so my colleagues were hiring at that point. In terms of who do I hire, I have my law clerks go once through the mass of applications that come in, and they rank them 1, 2, and 3, and I'll look at all the ones, everything that got 1s from all 3 of them. Actually, I'll look at anything that anybody gave a 1 to. And beyond that, I'm just looking for the same thing everybody else is, somebody with a strong record, who knows how to write, who I think would be fun to be with. I look at public interest things they've done. I don't want someone who's just sat in the library and written good exams their whole life. You know, I would like somebody who's engaged somehow in the world, but it's really the professor recommendations that help you separate them out at that level.
Judge Feinerman.
Yeah, my experience is similar. I think that the plan is kaput. if not formally, then certainly in substance. And if you're on Oscar, you'll get 700-800 applications, and it just is impossible to go through them all. So what I end up doing is I just rely on certain professors at Stanford, where I went, and at Northwestern and Chicago, who call me up, and I depend on my clerks. If my clerks know of somebody who was a year or two behind them in law school, who they really respect, that means a lot to me. And that's really how I sift through the pile.
Right, well, thank you all, and obviously there's a lesson here, which is get to know law professors. And this is a great place to get to know law professors, and maybe you meet a few judges, and that's wonderful as well. And I think being active in an ACS chapter is the sort of public engagement that would draw the eye of judges. So let's give this fine group of judges a round of applause.